conference is about sanctions and deterrence, and that is an important issue because sanctions are the key instrument traditionally to improve deterrence. But are the sanctions we are imposing, are they sufficient to be deterrent, or is there over-deterrence? And as the range of sanctions varies significantly from jurisdiction to jurisdiction, there's probably no single answer. Some can only impose administrative fines, others can also impose director disqualifications, and others have criminal sanctions with jail sentences up to 5 years. At the EU level, so by the European Commission, fines are the only tool in the toolkit. In 2006, the Commission reviewed its fining guidelines. That has led to a very significant increase in the average level of the fines. But when you look at the really high fines, except I think in one case there were always repeat offenders. So the lesson seemed to be that the previous level was not really sufficiently deterrent. And it's too early to know whether the present level is sufficiently deterrent. I don't think there has already been a repeat offender who had been sanctioned before under the 2006 guidelines. The right issue is the one that has been put on the agenda and is already to a significant extent addressed by Vice President Almunia. That's the difference in impact a fine has depending on the product range of the company that's involved in the infringement. If you have a very narrow product range, that means that most, if not all, of your products are involved in the affected by the infringement, then the sanctioning guidelines lead to a proportionally very high fine, while if the product's range affected by an infringement is let's say only 1 or 2% of your total turnover, the impact of a sanction calculated on the basis of the turnover affected, the affected turnover, is obviously much lower. Is that fair? Is that helping deterrence? No, it may well mean that the same guidelines can in some cases lead to over-deterrence and in others to under-deterrence. I think there was a general consensus on the panel that sanctions for individuals are useful. The issue was more, should they be criminal sanctions, or will administrative fines be enough, or in between should we go for director disqualifications? I think criminal sanctions, and then especially jail sentences, are the most efficient. I guess everybody agrees on that. The empirical evidence that has been gathered points in that direction. But introducing criminal sanctions in a competition law regime is not easy. First, at the EU level, it is not possible. And in member states, depending on their legal system, you really have to see whether they risk not to paralyze the administrative procedures, and in that case, we fear that the impact of introducing criminal sanctions may be negative instead of positive. Oh, there are quite a number of events, especially in Brussels, but what makes this conferences a bit special, standing out, is that you have more of a debate between the academia enforcers and the bar, which is only to be expected as the conference is organized by 2 universities.